You're paid on a contingency fee basis?
Not a contingency fee.
If the home doesn't sell, you don't get paid. Is that correct?
Correct. That's right.
Okay. So there's benefit in the home selling sooner, but there's no injury to you at this point, correct?
At this point, time and effort based on my team's, workload is just an ongoing, I guess you could say, injury to the process. And so,
and we're not saying that you're not talented at your job and not capable of doing your job, but delaying this sale.
15 minutes, one divorce, and a default judgment hanging everything in balance. One spouse claims no notice, the other says negligence. Addresses, emails, and missed hearings collide fast. Stay sharp as this courtroom unravels accountability. Versus mistake. Subscribe, like, and share. For dramatic legal breakdowns today, right now, here, please.
All right. You all are set at 15 minutes aside. This will include any opening and closing statements should you choose to make one, as well as any examination. Attorney Matthews, would you like to make an opening statement at this time?
Just briefly, Your Honor. So my client was pro se at the time. There was an order withdrawing her prior attorney. Her prior attorney left a prior client's address within that order. My client did not receive notice of the trial and was unaware that the trial was proceeding. She actually believed that the case had been dismissed prior based off the way that things read. And I'm prepared to present evidence and testimony supporting the same today.
Thank you. Attorney Cohan?
Yes, Your Honor. Basically, her noncompliance and failure to engage with the court in the withdrawal of her attorney with checking that order, with refusing to review that order, right, basically makes her negligent. Additionally, she knew she was in a divorce. She never received a dismissal notice. She should have known something was going on. I did everything as required under the Texas Rules of Civil Procedure. I'm sorry, Ms. Rivera, I'll slow down. Additionally, she has not met the final Craddock factor in showing that my client would not be injured. My client would be injured with the granting of this motion for new trial because of the attorney fees incurred and because of the receiver who has been appointed, who is attempting to sell this house, right, would be injured as well. And it's a result of my client. I would not want it to be liable. The award as offered, right, does not deprive Ms. Odemegwu. It allows her a remedy. If there is additional property out there, she can go back for a post-divorce division of property. And I don't think a motion for new trial is appropriate at this time. Thank you.
Thank you, counsel. Attorney Matthews, you may call your first witness.
All right, I'd like to call Blessing at this time.
Yes.
Please state your full name for the record.
My name is Blessing Shinyere Odumegwu.
Okay, perfect. And your prior attorney withdrew on December 27th, 2024. Is that correct?
Yes.
Okay, and there was an order on the motion for withdrawal of counsel that was entered. Is that correct?
Yes.
And at this time, I'm going to share my screen. This order has been admitted as Exhibit W1. In this order, it states that a dismissal hearing was going to be held on February 7th, 2025. Is that correct?
Yes.
Okay, and you believe that the case would be dismissed on this date, and you believe that it was dismissed on this date. Is that correct?
Yes.
Okay, and then further down, it says that all notices are to be delivered to you at 2529 Winthrop Drive, Dallas, Texas, 75228. Have you ever had any association with this address?
No, ma'am.
You don't know anybody who's lived at this address?
I have never seen that address till last week or 2 weeks ago.
Okay, and so you've never lived at that address, you've never seen that address before.
No.
The owners listed online through DCAD in an exhibit W2 are Segovia, Fortunato, and Rosalinda Boxtha. Neither of those names ring any sort of bell to you. Is that correct?
No.
Okay. And what address do you live at?
118 Woodland Cove, Coppell, Texas, 75019.
And do you own this residence?
Yes.
Okay. And who lives there with you?
I live here with my 3 kids and my spouse.
Okay. And did you ever receive a notice of trial to that address?
No.
Okay. And is it possible that your spouse would have intercepted any mail to you at this address?
Objection, speculation.
Most likely. Most likely.
And again, objection, speculation.
Sustain.
Thank you. And while you're representing yourself, did you believe that this case had been dismissed well in advance of the October 15th, 2025 trial date?
Yes, I had called over the phone and they told me that it's
Objection, hearsay.
Sustain. You can't tell me what anyone else said to you that's not present in the courtroom.
okay.
All right. And does this default divorce decree dispose of your entire marital estate?
Say that one more time.
Does this default decree of divorce dispose of your entire marital estate?
Can you explain what that means? Pretty much, yes.
It does not include bank accounts, 401ks, or other things that are in existence. Is that correct?
Yes, it doesn't include anything, debt.
Okay. And you did not receive at least 45 days written notice of your trial date on October 15th, 2025, correct?
Yes, ma'am.
And did you intentionally miss this trial date?
No, I did not.
Okay. Did you instead miss this trial date as a result of accident or mistake on behalf of your previous counsel?
No, I did not know about the case. I didn't know about the date.
Okay. And do you believe that justice will not be served unless a new trial is granted?
Yes, ma'am.
And no action has been taken towards the sale of your residence. Is that correct?
That's correct.
And we've informed Mr. Andrews, the appointed person to sell the home, of these pending proceedings. Is that correct?
That's correct.
And any additional efforts made by him after the date of the motion for new trial were not warranted. Is that correct?
Yes.
Okay. And do you believe that your spouse lacks knowledge of the characterization of the property and the values of the property at the time that he presented the default decree to the court?
Yes, he does.
Okay. And do you believe that he has failed to disclose property in the decree that was entered?
Yes.
Okay. And after the divorce was granted, has your spouse expressed to you that he believes that the two of you are still living together as a married couple?
In some ways, yes.
Okay. And in your opinion, does your spouse have a mental illness?
Objection, relevance.
What's
Yeah.
the counsel?
Your Honor, we've also set a motion to show authority. His capacity comes into question and ability to enter into a contract with a divorce decree being considered a contract.
Not set for today. Not relevant.
Sustain.
Your Honor, it should be set for today.
Sustain. You may ask your next question.
Yes, Your Honor. Does your spouse have an issue with drugs or alcohol?
Yes.
Objection, relevance.
Sustain.
Okay. I'll pass the witness for now.
Okay. Cross.
Ma'am, did you receive a copy of the motion to withdraw as counsel from your previous attorneys?
Things get messy when testimony wobbles. She says no notice, no emails, no trial awareness, yet records show filings and disputes over service. Meanwhile, they're still living together. That contradiction fuels drama. Was this negligence, bad communication, or strategic silence? The suspense now shifts to credibility before judicial decision-making begins.
I don't recall. I spoke with her over the phone.
Did they tell you they were dropping you as a client?
It was a mutual agreement, yes.
And you did not sign the order, correct?
What order?
The order for withdrawal of counsel. Correct?
I don't recall. That was last year. I don't recall.
And you never received an order for dismissal of the case, did you?
I'm trying to think. I called over the phone. I spoke to someone.
Objection, non-responsive.
Sustain.
It's not my question, ma'am. My question is, did you receive an order from this court dismissing your case? Yes or no?
I received something that says the case will be dismissed.
Objection, non-responsive.
Sustain.
Did you receive an order for dismissal?
I don't recall. I can't remember. I'm trying to think.
Ma'am, is your email address odemegwb@aol.com?
Yes.
And you did receive a notice of exhibit conference to that address, correct?
No, what exhibit conference? What is the exhibit conference? Please clarify that for me.
Ma'am, if you look at my exhibit, there is a service to your email. It is at odemegwb@aol.com.
When
At
was
this
it
point
sent?
in time,
Objection assumes facts not in evidence. This
Yes.
certificate, this e-filing
Offer
receipt does not
one-
include an email address.
offer respondents 1 to 4.
Okay, overruled. Which exhibit are we looking at?
Sorry, Judge, I'm trying to download them right now. I'm on my phone. I got called to Collin County.
I can share my screen if that's helpful.
Yes, please.
That would be helpful.
Wait, hold on. Am I giving you e-filing history? This is your exhibit 4.
Thank you. Offer R1 to 4 at this time.
They're already admitted.
Perfect. Would you mind scrolling down for me, please, Ms. Matthews?
Okay, we're on page 2.
Further, please. Keep going. Keep going. Keep going. So you never received your testimony is today. You never received the notice on that day.
No, I did not, because my email address was not with the court till November when I went over there and gave them my email address. I've never received anything till November when I filed a motion before I got my attorney. I've never received anything via email.
But Odemegwb is your address, correct?
Odeme will be at AOL is my email address, and it got updated into the system in November.
And you never responded to the discovery I sent you, correct?
Well, how did you
Objection
send it?
relevance.
How did you send it?
Hold on 1 second. The objection is to relevance.
Yes, Your
Sure,
Honor.
Judge. Here's what's going on. I sent her discovery in my R2 and R3 after the alleged dismissal date occurred.
When? How? How did you send it to me?
Ma'am, you cannot speak.
Oh, I'm sorry. I'm sorry.
The objection is overruled. You may answer the question. The question was, you never responded to the discovery I sent you, correct? It's a yes or no.
No, I didn't receive it.
Offer R2 and R3 are already in evidence. Your address is 118 Woodland Cove in Capel, correct?
That's correct.
And so far, you've refused to cooperate, Mr. Andrews, correct?
Who?
Mr. Andrews, the receiver.
I didn't refuse to cooperate.
Pass the witness.
Okay. Attorney Matthews?
Yes, Your Honor. The evidence that Mr. Cohen provided you with was supposedly serving discovery, correct?
Is this me now?
Yes, yes.
Okay. What did you ask me?
Mr. Cohen represented that he served you discovery, correct?
Yes.
But no evidence has been presented that you were sent the notice of trial to your Woodland Cove address, correct?
Yes, ma'am.
Okay, and that's where you would have received any mail or received any notices, correct?
That's correct.
And do you believe that a new trial would unfairly prejudice your spouse?
No.
No, okay. And do you believe that justice can only be served if a new trial is granted?
Yes.
Pass the witness.
Nothing further for this witness, Your Honor.
All right. Attorney Matthews, you may call your next witness.
Your Honor, that is it for me. I rest.
Okay. Attorney Cohen?
Call Kevin Andrews, Your Honor.
Okay.
Mr. Andrews, please state your name for the court.
Kevin Andrews,
And how are you related to this case?
I have been appointed as receiver to sell the marital property.
Has Ms. Odemegwu been cooperative?
Not as of this point.
How many times have you attempted to reach out to her?
We have sent emails and I've spoken with her on the phone initially, informed her that we would be doing a walkthrough of the property, and we sent the initial email explaining receivership. Then our team, my listing coordinator, has called, text several times, and she's avoided scheduling that initial walkthrough that is required for us to get the basis of the condition of the home and get it prepared for sale. And she's been avoiding that meeting.
Understood. And have you contributed work towards the sale of this house?
We have.
And if this court were to grant a motion to trial, would you be injured?
Well, yeah, just time on task, certainly.
Understood. Is there anything else you think we should know?
Mr. Odemegwu, excuse me, I apologize for mispronouncing the last name, has provided all material information that I've requested on the emails I've sent out to Mrs. Odemegwu. She has not responded with any answers for the seller information sheet that I need for title to begin the process of looking at any potential liens or anything on the home. She hasn't responded with any of the information that I've requested from her, but the husband side has.
Is this mortgage or is this home in any sort of financial distress?
Yes, there are several liens that are on the property. We felt like it was potentially in foreclosure, but it seems that has been postponed for the short term, so it could be brought back to light down the road.
Objection calls for speculation.
Aye.
All right. Is there any concern for foreclosure at this time?
Potentially.
Objection calls for speculation.
Any concern? Overrule.
I'm going to pass the witness.
Okay, cross.
Your Honor, I apologize. I can't see the date of judgment. Looks like it's 11/1/25. Could I have the court just confirm that with me? The date of the decree.
That's correct.
Thank you. Mr. Andrews, the final decree of divorce appointing you as receiver was entered on November 1st, 2025. Is that correct?
Yes.
Okay. And the motion to set aside default judgment and motion for new trial was filed by me in my office on November 14th. Is that correct?
Yes.
Okay. So you are aware that we are contesting this final decree of divorce, correct?
Yes, I was aware that there was a motion to contest.
Objection. Asked and answered.
Overrule.
And you're aware that there was a hearing set today, correct?
Yes.
And you're aware that there are no foreclosure proceedings currently on this property, correct?
Yes.
Are you aware that my client has been making the payments on this property?
No, I wasn't aware.
Okay. And the multiple follow-ups and things with my client in order to get the property sold while a motion was pending were not necessary, were they?
Yes. They were necessary.
There's no court order deadline for you to list and sell this home, is there?
No.
In fact, the longer my client makes payments on this home and they live in this home, they are receiving equity in this home. Is that correct?
Yes.
Has there been a contract with your office signed by my client?
No.
Have you paid any subcontractors to do things like take photos or survey the property?
No, I haven't been allowed access in the home.
Okay. Has the only office that's worked on this property been you and your assistants?
Yes.
And you're paid on a contingency fee basis?
Not a contingency fee.
If the home doesn't sell, you don't get paid. Is that correct?
Right. That's right.
So there's benefit in the home selling sooner, but there's no injury to you at this point, correct?
At this point, time and effort based on my team's, workload is just an ongoing, I guess you could say, injury to the process. And so,
and we're not saying that you're not talented at your job and not capable of doing your job, but delaying this sale a few months so that we can go to trial and figure out what the actual property division should be would not injure you if you got to sell this home, say 6 months from now.
the delay of going live is what
Objection unresponsive.
Sustain.
Do homes sell better around the holidays or in the springtime whenever people are getting out of school for the summer?
around the holidays, a lot of people have a lot of free time to look at homes. And so we do get homes under contract during the holidays. So there's two schools of thought on that idea.
Do they sell better in the springtime than they do around Christmas?
Traditionally, they do sell better in the springtime.
So you'd be just as capable of doing your job and being paid the same way 6+ months from now as you are right now, correct?
That's correct.
Pass the witness.
Okay.
Mr. Andrews, if this court sets aside the motion or the judgment, there's no guarantee you'd be the realtor, correct?
Correct.
And so that would cause an injury to you, correct?
Correct.
Pass the witness.
Right. Anything further from this witness?
No, Your Honor.
No, Your Honor.
Okay. Attorney Cohen, you may call your next witness.
Call myself for attorney fee testimony, Your Honor.
Go ahead.
Your Honor, my name is Mark Cohen. I am a board certified family law attorney licensed in Dallas County, Texas. I've been practicing for 14 years. I'm charging a rate of $300 an hour as a result of taking this case to trial, reading this motion, preparing for this motion, preparing for this hearing, writing a decree, sending a certificate of last known address, sending a service member civil release affidavit. I have billed 4 hours of attorney time. This is all reasonable and necessary in the amount of $1,200. Thank you.
Thank you. I have a question, Attorney Cohen. Your exhibit number 1, what is
Yes,
it?
Your Honor. Let me take a look.
I can pull it up for you. Hold on just one second.
Trial notice, Your Honor.
What was it?
That is the certified receipts for so those are the envelopes where I sent both certified and regular mail to Ms. Odemegu at the address listed in the order for withdrawal of counsel.
And Your Honor, I would just point out that the postage date is September 24th, 2025. So if that is what was inside of these envelopes, she did not get at least 45 days written notice.
And it's her job to object at trial for lack of notice.
And then furthermore, in our exhibit Y6, it shows that it was returned to original sender.
Okay, so Attorney Cohen, where did you get the address?
That is on the order for withdrawal of counsel signed by the court.
Your Honor, that Winthrop address is the...
It's on the second page for the order withdrawal of counsel.
Okay, right.
And as far as the court knows, that's all he could be responsible for unless he got an address directly from her. And she, by her own testimony, she didn't have an email address, right?
Not on file with the court, Your Honor, and she is living with his client, and he's aware that they've been living together this entire time. So there's no notice that was sent to the address that she actually resides at, and there's a mistake in listing that other address that has no association with her or her case, and the notice is going to that address.
The judge weighs fairness against consequences. Notice was defective, so the default judgment cannot stand. Still, mistakes cost money. By reopening the case, the court restores due process while ordering attorney fees. The house sale pauses, mediation follows, and a full trial finally decides property division under Texas family law.
All right. At the time of trial, was Attorney Matthews, was your client living with Mr. Cohen's client?
Yes, Your Honor.
Okay. So
They're still living together to this day.
all right. So this is what the court is going to do. The court is going to grant the motion to set aside the default judgment, but the court is also going to order your client to pay attorney's fees in the amount of $1,200.
Judge, what should we do about Mr. Andrews then?
Huh?
What are we going to do about Mr. Andrews then? Because he's been appointed as a receiver. Are we going to keep him on?
Oh, yeah. If the court still comes to the same conclusion that the residence should be sold, no matter what the split is, I can allow Mr. Andrews to still be appointed once again.
And I won't object to Mr. Andrews if that is what the court wants to do later. I do believe, Mr. Andrews, I didn't mean to insult you by this hearing. I do believe that you are very good at your job. I just have a job as well to represent my client.
Understood. Yeah, so that's what we'll do. We'll leave whenever the court is able to convene and we take this matter up on trial, or if you all go to mediation, which is actually a part of reopening the case. You all have to go through mediation. You have to go through the exhibit conference and tender your exhibits and everything like that. The court has first available in January.
For a trial date?
Yes. Because your client, pursuant to the credit methods, there is no reason to delay it. So we should be able to have a trial as early as January, right?
Yes, Your Honor. I will tell you that getting a mediator before then is going to be really, really tough. I've run against that challenge.
No, we'll appoint one. You all do not have to do anything about that.
Okay.
Judge, we couldn't do January because January would not be 45 days notice.
That's correct. What's today? December
15th.
So let's do March.
Okay.
What does everybody's schedules look like in March?
Pretty open, Judge.
Huh?
Pretty open, Your Honor.
I've got a kiddo with a spring break at some point in March.
And I do. Let me see what dates the court has available. One moment.
Thank you.
Okay, I have March the 3rd, March the 5th.
I've got both.
So March the 3rd and March the 5th.
And then I have the 10th, 11th, and 12th. But I think that your child's spring break, is it the week of the 9th or the week of the 16th?
It's the week after the 10th, 11th, and 12th. So the 16th. I could do March 3rd or March 5th. Blessing, would either of those dates work for you?
I'll make it work.
Okay.
Okay, so I have the 3rd and the 5th at 1:00.
Both good.
Both are good with me as well.
Okay, so I will schedule you all for bench trial on March 3rd, 2026. Let me add this into the computer. Or would you all prefer a morning? We can do a morning too if there's a preference.
I would prefer a morning solely because I pick up kids and I can't stay late.
Okay, yeah, we can do a morning. 9 a.m. on the 3rd. Does that work, Attorney Cohen?
Yes, Your Honor.
Okay.
Thank you, Judge.
Thank you, Judge.
BF 2407008. 320. At 9 a.m.
Thank you, Judge. May we be excused?
Wait a minute, 1 second. Would you all like in person or on Zoom?
In person.
In person, please, Your Honor.
Okay, in person.
Fine.
All right, I have you all set, and then Judge Lee will send you an email confirming when you all will have your pretrial, and it'll have your so your pretrial will more than likely be in January, and then you'll have she'll tell you who the mediator will be as well.
Thank you, Your Honor. And do we have a time limit per side?
Yes, you do. You'll get it at the date of that pretrial because she needs to see what the issues are.
Thank you, Your Honor.
All right, thank you all.
Thank you, Judge.
You're welcome. You may be excused.
Thank you.
Final takeaway: default divorces demand precision. Wrong addresses, missing notice, and self-representation can unravel judgments fast. This case resets the fight, orders fees, and schedules trial. Justice pauses, not ends. Like, comment, and subscribe for more shocking courtroom stories and real legal lessons every week right here with clarity guaranteed.